If an IMO calls you an agency owner, but you can lose your downline, your carrier access, and the business you built when you leave, did you ever really own it? This is the question at the center of the Misty Cintron lawsuit against Symmetry Financial Group and several individuals, with the proposed amendment trying to add Quility Insurance Holdings. And nothing in this video is a verdict by any means. These are allegations and counterclaims from public court filings. I will leave the access to the documents down below. Symmetry obviously denies key allegations and has filed counterclaims. I'm showing the documents because agents need to understand what these contracts and lawsuits actually say. So without further ado, let's get into it, my dear friend. So right here, you're going to see the docket, and over here we have Misty Cintron against Symmetry Financial Group and all these people. We got Matt Goforth, Brian Delaney, Ian Graham, Brad Smith, and we're going to be looking over a couple key documents, mainly these ones already pulled and redlined ahead of time to just be respectful of your time on this video so we can get just to the meat and potatoes. All right, so let's go right to this. This is Index 86. This is plaintiff's motion for leave to file a third amended complaint. And this matters because this is where the plaintiff says Discovery produced new information and she now wants to add Quility Insurance Holdings as a defendant. So as we're going through here, what I want you to notice is the original case started as defamation and civil conspiracy, and she now wants to add Quility. She claims Discovery showed a Quility employee sent emails to carriers, and she also wants to add claims for unfair/deceptive trade practices, wrongful interference, and a breach of contract and fraudulent inducement. All right, so this motion basically says the original complaint alleged defamation and civil conspiracy, and the proposed amendment seeks to add Quility based on Discovery allegedly showing Quility-related carrier communication. So the case is no longer just someone said something bad about me. The plaintiff is trying to turn this into a case about carrier interference, which is a big one. Ownership promises, can't wait to tackle that. And whether the company used a for-cause termination to take control of what she built. So we're on document 86. We're going to go down here. So she is adding Quility onto this wrongful interference with carriers, and Quility Senior Vice President of Sales Operations also had personally called multiple carriers about the plaintiff. So when we scroll down to this, page 3, what you're going to see is plaintiff further proposes to amend the second amended complaint by adding allegations regarding representations that agents could become true owners of their own agency at Symmetry Financial Group, or SFG. These allegations and related unfair or deceptive trade practices and fraudulent inducement claims are located at paragraphs 20 to 24. So in its counterclaim, Symmetry alleges that plaintiff breached an ICA with Symmetry that she signed on or around March 12th of 2021. She breached the confidentiality, non-solicitation, and non-disparagement provisions set forth on the ICA. These contracts are always so goofy. So plaintiff entered into an agency manager ownership agreement, the agreement, with SFG. And unlike the ICA, the agreement provides that SFG could not terminate or cancel the agreement. So plaintiff's relationship with SFG, or plaintiff's contract with various carriers for which SFG served without cause, the agreement further provides that it controls to resolve any inconsistencies with the ICA. So plaintiff proposes to amend the second amended complaint to add allegations that Symmetry breached the termination clause of agreement by terminating the agreement. So if we scroll down here to page 6, it's going to say, in one promotional video produced by SFG, Defendant Delaney stated, Symmetry Financial Group can help you build a business with the opportunity for true ownership, freedom, lifestyle, and financial legacy. And the Symmetry system also empowers you to build your own agency. On SFG's website, it stated that agents with Symmetry leverage all of this to connect clients nationwide with life insurance solutions that fit their needs, all while building a career that they truly own. that will leave a lasting legacy. The website also identified ownership as one of its core values, stating, "We act like owners because we own it." Despite these representations, SFG imposed such unconscionable restrictions on the portability of an agency that an independent contractor who left SFG voluntarily or involuntarily would lose all their downline agents. Interesting. SFG knew at the time it made its representations regarding true agency ownership that those representations were false. Cintron viewed the promotional video and the representations on the website regarding the ability to own her own agency as an independent contractor with SFG. In Cintron, she reasonably relied on these representations, and based on her belief that she could attain true ownership of her own agency with SFG, she signed the ICA, the independent contractor agreement with SFG, rather than sign with another IMO, insurance marketing organization, that offered much higher percentage on commissions than SFG. Conversely, these organizations collected for themselves a much smaller percentage of the sales from insurance policy sales than SFG. And at relevant times, Cintron excelled in her work for SFG, often working 14-hour days across multiple time zones. And then on May 19th, she entered into an agency manager ownership agreement with defendant SFG. The agreement provided that SFG could not terminate or cancel the following without cause: the agreement, Cintron's relationship with SFG, or Cintron's contracts with various carriers. Following the parties' entry into the agreement, Cintron continued to excel in her work duties and in her leadership for downline agents. In December, she wrote $426,000 of personal production, and her team did $1.2 million in insurance sales. Now, here's the first issue that agent like you share about is your ownership promise. She was allegedly told that they could become true owners of their agency. Promotional language explicitly is saying, like, it'll, my bad, I gotta use words like allegedly in these videos about true ownership, freedom, lifestyle, and financial legacy. And the website language allegedly said agents could build a career they truly own. I've seen the same videos. I was at the Cintron. Anyway, Cintron claims, I gotta not put personal stuff in here. So Cintron claims she relied on this and chose SFG over various other IMOs with higher commission percentages. And this is where you have to stop and ask, like, was ownership defined in the contract, or was it just recruiting language? If ownership only exists in a hype video, you do not own anything. It needs to exist in the contract. All right? So if we finish up right here, she did $1.2 million in sales that year, and she got the position of agency director. In January, she began investing $3,000 each month from her personal funds into recruiting agents for her own agency. In mid-2023, she developed and self-funded a private training with lead generation portal exclusively for her team. SFG provided training materials to its independent contractors, but Misty did not find them to be effective, so she developed her own training materials for her team. Guys, if you're getting training materials from your IMO, they're probably, side note, if you need actual training, go down below, or just go pick up this book on Amazon, The Lead, Why Good Agents Lose Sales, They Never Had a Chance to Close. It'll teach you how to build your own lead machine. Do not rely on an IMO to provide you leads. It's an idea. You're going to pizza when you should have French fried. You're going to have a bad time. Hopefully you get the South Park reference. So similarly, SFG sold leads to its independent contractors, but Cintron found that those leads had a low success rate. For generating sales, and as a consequence, she stopped purchasing SFG's leads. Within her first year as an independent contractor with SFG, good job, Cintron spent approximately $10,000 of her personal funds for her initial setup of her lead generation system for her own agency. In December 2023, SBLI announced that Cintron placed second in personal production, and that her overall production was $312,000, and her team's production was $1.63 million. She currently had 71 downline agents that she had personally recruited and trained working on her team at that time. And at all relevant times, in her performance of her work duties, she complied with all material, legal, regulatory, and ethical requirements, as well as defendant SFG's written policies and procedures related to the procurement and sales of life insurance policies and related transactions. And we'll go into this next part here in a second. But this matters because she's not describing herself as a brand new agent who wrote a few policies and then got mad. That's all the stuff she was doing. And then agency director and built serious production. Like, she built something real. She became an agency owner, like I said. She signed an agency manager ownership agreement. She had $426,000 of personal production and $1.2 million team production in 2022. And in 2023, allegedly $312,000 personal production, $1.63 million team production, and 71 downline agents. This is why the case matters. If she was right, this is not just a lost contract. This was a whole business structure she had built. Downline agents, carrier access, overrides, a book of business, and future income. Like, that's what's on the stake here. Now, let's look at what triggered the blow up. On or around December 2023, Mark Jaffe, a long-standing agent with SFG, requested a transfer to Cintron's team. Under SFG's policy, an agent who transfers to another team cannot transact business for 6 months. The 6-month sit-out rules effectively forces an agent to remain on a team that may be stagnant, financially unproductive, and or a bad fit for that agent, because transferring means foregoing income for 6 months. I can't stand that shit. Cintron negotiated with SFG regarding a sit-out rule for Jaffe's transfer. During those negotiations, Cintron informed SFG of her dissatisfaction with certain SFG policies and informed SFG of the fact that she had received an offer from another IMO, which she had declined. On information and belief, defendants responded to Cintron's disclosures by scheming to make false assertions and accusations about Cintron so that SFG could pretextually terminate her contract for cause in an effort to retain Cintron's book of business and independent contractor agents. Scheme. In furtherance of the scheme, on information and belief, defendants also pretextually made false assertions and falsely accused her of committing acts of fraud and dishonesty, and otherwise accusing her of having violated the law and or professional ethics as it pertains to the sale of insurance policies. On information and belief, defendants' motive for engaging in the scheme against Cintron was to cause pretextually major carriers of life insurance policies to disqualify her from being an approved broker for the various carrier companies, thereby removing her as a competitor and acquiring her independent team of agents she had personally recruited and trained. So let's see what's next. The disqualification by major carriers was tantamount to banishing Cintron from the business of brokering life insurance policies for new and existing clients and removing her as a competitor. Defendant's scheme essentially permitted them by default to unfairly and deceptively obtain or hijack Cintron's client list and or book of business of life insurance clients, in addition to securing Cintron's team of independent contractors that she had recruited and engaged to her own labor and expenses for SFG's business purposes. So if we look at this, Mark Jaffe wanted to transfer to Cintron's team. Symmetry allegedly had a 6-month sit-out rule, and Cintron says she negotiated over relaxing that rule. She also disclosed dissatisfaction with SFG policies and that another IMO had made her an offer. She alleges defendants then formed a scheme to terminate her for cause, retain her book in her downline, and remove her as a competitor. So this is the plaintiff's theory. She became valuable, then she became a flight risk, and then the company allegedly used compliance accusations to take her out. And that is her allegation. Symmetry's side is that she breached the agreement. We'll get to the counterclaim here in just a moment. So in furtherance of the scheme and for pretextual purposes as alleged supra, SFG and Quility, through their secretary and general counsel, provided Cintron with a purported notice of for-cause termination for having allegedly entered inter alia in one or more fraud or dishonesty with respect to business dealings. Such accusations made by defendant Goforth about Cintron in his notice dated February 12, 2024 were false, and on information and belief, defendant Goforth was aware that the accusations were false when he made them. At or following Goforth's issuance of SFG's notice, Defendants and intentionally created, distributed, and published numerous false statements to others about Cintron as alleged infra in furtherance of the scheme. On February 12th, Rhonda Wright, a Quility employee in furtherance of the scheme and in the course of the scope of her employment with Symmetry, emailed 7 carriers who had contracts with Cintron. In her respective emails to these carriers, Wright requested that each carrier terminate for cause its contract with Cintron. Additionally, Wright made the following false and or misleading statements. We learned, and she admitted, she was allowing her downline agents to submit business using her writing number, and she was paying the agents on the side, and 2, allowing and teaching agents to pay commission splits to agents from her sales where the payee wasn't licensed but was involved in the sale. Collectively, false statements. In truth, Cintron had never allowed downline agents to submit business using her writing number unless Cintron was present and assisted in the transaction. Cintron made this fact clear to SFG prior to termination. Moreover, the practice of allowing new agents who had not received a writing number to write on an upline agent number had been endorsed by SFG. Cintron had allowed on a few occasions an agent who had discovered that the customer resided in a different state than what was indicated on the initial paperwork, and one in which the agent was not licensed, to utilize Cintron's number in order to finalize the sale. Again, Cintron always assisted with the transaction and was the agent of record for the transaction, so she stepped in and took over the sale for her agents. The practice was endorsed by defendants. Contrary to Wright's statements, Cintron would not split the commission with the downline agent in such circumstances, but would give the entirety of the commission to the agent in the form of the bonus, which was encouraged by upper management. None of Cintron's foregoing actions were unethical, violated any agreement with SFG, or violated any applicable laws. On information and belief, Ellison knowingly and intentionally made and published the following false statements about Cintron on or after the dates listed. February 13th, 2024, Ellison disparaged and lied to representatives for insurance carriers, Pan America, by telling them that Cintron was allegedly or unethically permitting agents to write on her link, which caused Pan America to terminate Cintron's ability to write any more business or any more insurance plans for it. On February 14th, Ellison notified Bradley White of Carrier Mutual of Omaha that she allowed Mark Jaffe to submit applications under her production number and that was illegal and fraudulent. On February 15th, they notified Americo that Cintron had allowed other agents to submit agents under her name and identification with the company and otherwise engaged in illegal or fraudulent activity. Ellison also falsely accused Americo's employees, falsely informed Americo's employees that Cintron was illegally, fraudulently, and or unethically training other agents to pay commission splits to agents who were involved in specific sales but were not licensed with the particular carrier. Collectively, false statements. 3 insurance carriers relied on the false statements made by Wright and Ellison and have terminated their contracts with Cintron. Additionally, other carriers will not contract with Cintron based on her terminated contracts. So this is the most serious allegation of the entire filing. The proposed complaint alleges that Quility employee emailed 7 carriers and requested that each carrier terminate for cause Cintron's contracts. And then she allegedly allowed downline agents to submit business using her writing number. Can't do that. She allegedly paid agents on the side. Can't do that. She allegedly taught agents to pay commission splits to unlicensed agents involved in sales. Can't do that. Well, it's allegedly. Now, if those statements were true and properly reported, that is obviously a big compliance issue. However, if those statements were false or misleading, that's career destroying, my dear friend. And personally speaking, if you're signing any, do your due diligence, have some discernment before you sign anything with anybody. These people can come in and terminate anything. Just go down that route. Carrier, and why this is so important is carrier appointments are like oxygen in this business. All right. If the carrier relationships get poisoned, you can be effectively removed from the business without a non-compete ever being enforced. And this is why I think the carrier email section is so much stronger than the agency ownership section. You can be ownership language can be argued as marketing. Carrier communications are concrete, right? So this complaint alleged a Quility employee emailed 7 carriers and asked them to terminate Cintron for cause while making statements about writing numbers and commission splits. Now let's go down to the actual claims. So this is where claims really start to make sense. We go down to the cause of action stuff. So first, claim for relief. So the allegations contained in the foregoing paragraphs are hereby re-alleged and incorporated. So defendants individuals knowingly and intentionally wrote, stated, printed, or otherwise caused to be distributed and published to others the false statements about Cintron. So she says false statements damaged her professional reputation. If we go down to breach of contract, she says that they did not have valid cause to terminate the agreement. If we go down to unfair or deceptive trade practices, she says this was not a private contract fight, but unfair conduct in commerce. If we go down to the fourth claim, she's basically saying this ties to the carrier contract. It's wrongful interference with her contracts that she was promised. And number 5, fraudulent or inducement. If we go down to this section, fraud/fraudulent inducement, this ties to the agency ownership promise, and all this will be down there to look at as well. And number 6, civil conspiracy. She says multiple defendants acted together. All right, so this is where all these claims really start to make sense. You can have your own you can formulate your own opinion about this. Now let's go over to the that you should see, which is, if you go over here, it's going to be number 64. So we just finished up 86, which you can see up here. Now we're going to go to number 64 down here, and I've just redlined these ahead of time, because if I stop the video right here, it would be one-sided. So now we need to look at Symmetry's answer and counterclaims. Okay, so Symmetry obviously denies a lot of the allegation. However, Symmetry admits that there was an independent contractor agreement. They admit that there was an agency ownership agreement, but they deny the plaintiff's version of what those documents mean. Here we go, getting lost in the definition soup once more. So Symmetry's counterclaim is basically, she breached the agreement. So if we're going down here, Symmetry defendants deny the remaining allegations of paragraph 4. Let's just read all of them. Symmetry defendants lack knowledge or information sufficient. How do you lack knowledge? To form a belief as to the truth of the allegations in paragraph 1 and therefore deny the same. The allegations in the first sentence of paragraph 2 are admitted. The remainder of paragraph 2 is denied. The allegation of the first sentence of 3 are admitted. The remainder is denied. Symmetry defendants that go forth traveled to and within the state of North Carolina for business purposes on at least one occasion, except as expressly admitted. Symmetry defendants deny the remaining allegations. They admit Brian Delaney worked with as an independent contractor. They admit Ian Graham worked with them as an independent contractor. They admit that Bradley Smith worked with Symmetry as an independent contractor. And so a lot of this is just them denying. And so we're about to go to the next document, but like I said, Symmetry's because she breached the agreement. So she allegedly breached confidentiality of her stuff. She breached the non-solicitation, she breached the non-disparagement, and she breached the poaching and public disparagement stuff. So termination for cause, fraudulent conduct, and dishonest acts. So the defense narrative from Symmetry's perspective, how I'm reading this, is not that nothing happened. The defense narrative is that the contract controlled, she violated it, and any communications or actions on their behalf were justified. This is why you agents have to understand the documents before just choosing a side. Like Misty says she built something she owned and then they took it from her, essentially. Symmetry says you built it inside of our platform and then you violated our agreement. Okay? So have their argument. Let's go over to Exhibit A now. So this is the actual contract. So this is document 30, by the way. If you go down here to index 30, where'd you go? If you look down here, you'll see index 30 somewhere if you want to go download it right here. Now, this is exhibit to answer of defendants Michael Brandon Ellison, Matthew Allen Goforth, and Symmetry Financial Group to plaintiff's amended complaint. So here is their counterclaim. Exhibit A, we have the independent contractor agreement. And this is the part where most agents skip, which is usually the part that controls the entire fight, the contract. So let's look at the opening recital. So the ICA, this agreement is entered into effective as of the date set forth. Signature, blah, 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 blah. And the company is an IMO that engages independent sell life insurance and various insurance carriers with whom the company works, the carriers. The company has invested and is continuing to invest significant sums to develop a customized and proprietary customer relationship management, lead management and allocation, compensation management, sales management platform with the producer self-service portal, the proprietary sales software for the company's independent contractors to use, manage every aspect of their independent sales business and agencies. The contractor desires to sell or continue selling life insurance and related products on behalf of the company for the company's carriers. As an independent contractor of the company, and to be given access to use the proprietary sales software at no charge to the contractor. The company is willing to allow them to keep selling related products on behalf of the carriers as an independent contractor and to give the contractor access to the sales software as soon as it is available at no charge to the contractor on terms and conditions contained herein and during the term of this agreement. The company is also invested in continuing to invest large sums in sales training and carrier product training. Yeah. The company is willing to allow the contractor to utilize sales training and carrier product going forward in connection to their work for the company on the terms and conditions contained here within. The company also has invested sales leads in its leads programs, which makes the company available to the independent contractor insurance agents at a substantial discount to the price those sales leads actually cost to the company. Once again, go pick you up a copy of this. You don't have to worry about fucking buying leads. It's stupid. The contractor desires to utilize those sales leads going forward. Personal opinion, of course, nothing desirable about them. The company is also invested in continuing to invest in various incentive bonus programs. I don't want bonuses. I just want all my commissions. Personally, I don't want to go on trips with people I don't like. All right. So, performance of services. The contractor shall determine the methods, details, and means of performing the services, recitals. So if you go down here for the lead section, basically, contractor receives commission or other compensation in connection with those sales. They should be responsible company for any and all amounts charged to those downline agents or company by any lead provide or for leads ordered by those downline agents and for any amounts charged to those downline agents. For the company, so leads used only for company business except as provided below. The contractor may represent, perform services, and be employed by such additional clients, persons, and or companies as the contractor in contractor's sole discretion sees fit. In no instance, however, may the contractor utilize leads provided by the contractor by or through the company for the sale of insurance or related product or anything else through or for another insurance marketing organization or another entity or individual or for the contractor individually. So you can't sell other companies' products to the leads you buy from them. Confirmation is to be broadly defined. Leads and lead system pricing, non-solicitation. You agreed of 18 months after termination. So non-disparagement. Non-disparagement's a funny one. The contractor agrees at all times after the effective contractor will not directly or indirectly through any entity or otherwise nor cause or cooperate with others to criticize, ridicule, disparage, defame, or otherwise make unfavorable statements and or unfavorable comparisons to the company, business practices, compensation, promotion guidelines or policies, contract levels, bonuses or bonus programs, carriers, services, policies, employees, officers, members, or managers with or through any written or oral statement or image, including but not limited to any statements made via websites, YouTube, it's probably my fault, Facebook, blogs, social media postings, or any website that allows posting messages, posting to the internet. You can't say fucking shit about these people, okay? I can. So goofy. Participate in, and I'm doing this of my own free accord because I've been following this shit. There's 3 other cases I'm looking at right now, TCPA stuff, RICO cases. I've got some videos for you guys and you can come up with your own stuff, but like, you essentially just, they don't allow you to say anything about them. It's funny. No prior representation / claims. Contractor agrees that he or she shall not claim otherwise in any proceedings. Ownership of company names. Yeah, you can't claim that you own them or you have ownership. Either party may terminate this agreement at any time, equitable relief. So SFG describes itself as an IMO, insurance marketing organization, and it says it provides software training, carrier product training, lead programs, incentive motive programs. I don't know what the hell I just said there, incentive programs. It frames these as company investments. The ICA says SFG invested in proprietary sales software, sales training, carrier product training, and sales lead programs and incentive bonus programs. This is Symmetry's best business argument. They're going to say we platform the software, the training, the leads, the carrier relationships and systems. So when someone leaves, they cannot just take the structure and then raid the organization. All right. So I showed you guys the non-solicitation, non-disparagement, confidentiality, no reliance, entire agreement language, and included down here in my red lines I gave you. Now this is a trapdoor for agents. The recruiting pitch may sound like entrepreneurship, but the contract, to me, may read like platform control. All right, so the issue is not whether restrictions are always wrong. The issue is the word ownership means anything once the contract is signed and the restrictions kick in. So let's look at the scoreboard, so to speak. This is Cintron's version, is that she was promised true agency ownership. I built a valuable team. I became a flight risk. They manufactured calls, contacted carriers, and damaged my reputation and kept the economics of what I built. That is essentially what she is saying, allegedly. And allegedly for Symmetry is that, hey, this girl signed contracts, had access to our platform, our resources, and she breached the agreement. She poached agents and she disparaged the company and the contract controls. Now, the case is not going to be decided by who sounds more emotional. It is going to be decided by documents, communication, carrier emails, contract language, and whether the alleged statements were true or false. Now, here are the questions every agent should ask before joining any IMO. What do I actually own? Like, number one, what do I actually own? Do I own my downline? Do I own my renewals? Do I own my CRM data? If you're using a IMO provided CRM, get out of there. I'm gonna have a link down below to Agent CRM. Alex, dude, he's not an IMO, he's not an insurance agent, so he built it for insurance agents. That's the CRM I personally use. Go check that out. I'll get a little piece for my niece if you sign up for my link. If you like to support me, but in any case, you can just go get your own Go high level account. I don't recommend it because you have to build from scratch. I've done it plenty of times. It's not fun. However, just let's finish the question. What do I actually own? Do you own your leads? Do you own your training assets? Do you own your agency name? Do you own your carrier appointments? Who owns each piece? All right. Number two, can I sell it? If you cannot sell the agency without company approval, your ownership is limited. Your ownership is limited. All right. Number three, can I leave with it? If you lose the downline when you leave, you may not own the agency. You may not own the agency. So read them over. What happened, Jason? This is the nuclear clause. All right. That's the nuclear clause. If someone could just do that, like essentially they're doing here, allegedly, this is why I piecemealed all of my contracts together. Obviously, if I'm doing anything illegal, I would get in trouble for that, as I hope I would. I don't know if I'd want to be in an industry that's just running rampant and fucking chaotic. But if my upline, so to speak, and I'm practically direct to the carriers at this, which is the best position to be in, because there's no one above me holding something over my head. I encourage you to all seek a position like that. And understand the point is not to have an upline or get help or any of that stuff. It's to own every piece of the process, to be what people like Henry Ford called back in the day, vertically integrated. You own every piece of the distribution. All right. So I have my own contracts. I have my own lead platform. I have my own, keep all of my own data. It's all under my control. And is it hard? Yeah, but fucking business is hard. Think you're going to get through life without being a little hurt, going through a little stress? Like, get out of here. So number five, who controls carrier relationships? If the IMO can poison those relationships, you are vulnerable. You are vulnerable. If they can send someone, hey, cut their writing numbers off, put them earned. Number six, what does non-solicit actually restrict? Can you contact agents you recruited yourself, or do you forego all that? Do you have to give it all up? What if they come to you? What if they come to you after you've left, you've terminated your language on anything you've signed? Number 7, what does non-disparagement actually restrict? Can you publicly explain what happened? Can you publicly explain what happened? And like, would she get in this video? And number 8 is defined in writing. Here's my thing. If it is not written, it's not real. If it is not written, it is not real, my dear friend. This is the real point of the case. Not whether you like Misty, not whether you like Symmetry. The point is, do agents understand what they are signing before they build their entire future inside of somebody else's system? All right. So I'll have all the documents down below. You're more than welcome to go look at them. Document with index 90. If you go back and look at that, it's going to say that the third amended complaint is not a verdict. It is a proposed amended complaint. The hearing on the motion is scheduled for August 19th of 2026, which I will be following this ferociously. And then the actual case management order currently sets trial for February 1st, 2027, discovery deadline October 30th, 2026, Halloween spooky. And dispositive motions to be heard by December 1st of 2026. And then my personal opinion, the agency ownership issue is the biggest lesson for agents, but the carrier email allegation is the biggest legal danger for the defendants. If the carrier statements were true and made for legitimate compliance reasons, Symmetry's defense gets stronger. However, if the statements were false, misleading, or selectively weaponized after she became a flight risk, that's a serious problem. So before you call yourself an agency owner, read the agreement and ask one question. If I leave, what do I actually keep? Let me know what you think about this case down in the comments, but that is where the lawsuit stands. It is not a verdict. These are allegations from Misty Cintron's side, and Symmetry has denied key claims and filed counterclaims of its own. But regardless of who wins, every agent should pay attention to the bigger question the case raises. When an IMO tells you that you can build and own your own agency, what does that even mean? Do you own the downline? Do you own the book? Do you own the renewals? A lot of agents out there don't get renewals, don't get second, third, 10-year commissions from the prospect keeping the policy. Do you control the carrier relationships? Can you sell the agency to anybody who wants to buy it? Can you leave with it? And what happens if they terminate you for cause? My opinion is very simple. Agents need to stop falling in love with the titles and start reading the contract, because if you cannot take it, sell it, transfer it, or protect it when the relationship ends, you may not own an agency. You may just own a title. So here's the question. If an agent builds a team, writes the business, trains the people, and funds the growth, but the IMO controls what happens when they leave, who really owns the agency? Drop your answer in the comment. Before you build your life inside of somebody else's system, read the agreement, because the title they give you does not matter nearly as much as what you still own when you walk away.